some contemporary developments. So the first part of the slide concentrates because Dr. Venkat Rao had spoken generically in the morning. So I thought first I will enlighten you. Most of you might be aware also, but still I will revisit rather for those who are aware on the learning outcome, the content and the concept of criminal law. Then secondly, what are the many methods that we teachers apply? How do we do the learning design? And what is the context of an instructor today in teaching criminal law? What are the different approaches? Third is traditional law teaching and the modern approaches to teaching. And how do we connect it to our context of criminal law? And 21st century skills pedagogy, how that is unique. We want you to discuss as well as we move with the slides. And then the last part I would like to bring in is in this context, which has started from online tools, cyber-based learning, internet-based learning, online-based learning to emerging trends with the artificial intelligence, especially with ChatGPT. Some of the tools which are used in research, which are used in preparing content for teaching. So this is how I would like to go about. Now, first of all, when we are talking about why do students learn, why do I teach? Why do students learn? What do I teach and what do students learn? How do I teach and how do students learn? If we think like the bygone days, if you go to Glanville Williams' book on learning the law, which is considered as a classic on anybody's passport to legal education as a student or as a teacher, he dedicates one chapter on law teaching. Now, Glanville Williams probably would have written this book in the early part of 20th century or at the turn of the 19th century, where the law teacher was lecturing and law teacher's word was taken as the gospel, and law teacher was the one who would store the knowledge, then synthesize that knowledge, make it easy and communicate or pass on to the students. Today it is not like that. We have moved from teacher-centric period to learner-centric period. So that is one part that we have to remember. So the tripods of quality legal education, as Carnegie report highlights, and earlier to that, we had many other reports on quality legal education, including India's Law Commission report, McBride report. The Carnegie report updated it and synthesized it, three parts: knowledge, skills, and values. If you're designing a course for masters, how much of knowledge? If you're designing course for undergraduates, how much of proportion of knowledge, skills, and values? So in undergraduates, they are knowing, they are understanding, and then in postgraduate, should be equipped to create the knowledge, not just learn, but analyze, not just apply, not just comprehend, but they have to create the knowledge. So the skills and values component and the knowledge component assume different proportions depending on the level of the program. In diploma, maybe you may have a 50-50 combo of knowledge and skills. But when you're teaching them in undergrad to be tomorrow's lawyers, you will have to be very careful about the ethics also that you infuse alongside maybe 60% knowledge, 30% skills, 10% values. When you go to LLM, they are already formed. So the majority portion is on knowledge and skills in terms of working with the knowledge for the sake of knowledge, not unlike graduation where you do it for profession. I hope I am making it clear. Therefore, the objective, what we call as course objective, which is aligned with the program objective, PO and CO, these have to be mapped depending on the level at which the program is. And within that, we have to integrate the quality elements of that particular program or education. We are talking of legal education. Suppose I was teaching engineering students, I would rather speak in a different way in terms of skills incorporating lab-based part. Whereas if we are talking to law students, skills incorporating internship part, or what you teach as simulation or mock. So these are all coming there. Now, values, you know that cardinal values for law are human rights, justice, gender, then equality, diversity. These values will come there. What Oliver Wendell Holmes long back called it as the inarticulate premise behind legal reasoning. Means something that is not articulate, but something that drives the whole outcome of the justice delivery or legal system. That's the first part I want you all to anchor upon. The second part is the skills that a law teacher has to, or criminal law as such, what can we think of? Or in any law subject, what can we think of? One is every law content in a course has got three parts. One is principles and theories, or what we call as the knowledge part, which is jurisprudence. So that is the first part. And also the concepts, they come within that. For example, in criminal law, we have mens rea, actus reus, or the criminal intent, the criminal motive, the actual act. Sometimes there may be a motive and intent, but it mightn't have fructified into action. We create problems on the basis of this. IPC itself has multiple illustrations highlighting this. So this is principle applied to real life problems or real life context. Now, as a law teacher, you cannot just read a bare act or make students to read a bare act. You will have to tell how each of those sections have been interpreted in various judgments, or the meaning that has come into that in the original legislation and how it has changed, while giving that meaning how historically they would have deliberated upon each of those sections. So legislative history is very important when a teacher teaches the law, because when that student tomorrow goes and sits as a judge, or that student formulates an argument for the client, then how that student will go beyond the black letter law of the legislation. Because the same word interpretation in the same context, interpretation in different contexts could deliver different results. So a teacher can give, teacher doesn't give the fish, but the teacher teaches how to fish. Or teacher doesn't give the sight, but teaches how to gives the sight to see that particular thing. Therefore, application to real life problems which are hypothetical or real in the form of cases which have been reported, and the critical thinking as to why case A outcome is different from case B. What is that crucial fact which changed the outcome, or what is that crucial political social background which made this law to be amended or interpreted. So students should receive that 360-degree insight, because the students will have to look at that real life problem in a very forensic way, in a very empirical way, without bias and without preconceived notions. So stretching the mind to ask questions and not to draw given conclusions. Your conclusion should not be your student's conclusion, because today you are in the classroom. When by the time student goes to the real world in 5 years or 10 years, so much would have changed. So the student should be given that kind of openness in the environment of learning. And student will have to experience a legal office environment. Even we teachers will have to have some stint in the legal office, at least as visitors or as interns. I send my teachers and I insist, if they don't have clinical experience. I mean, many of us would have received it as students out of our own interest, but nobody compelled us in our generation. You are younger generation, maybe you have. If you don't have, please experience a legal office environment. Next, the student should be, prepared for a versatile legal career, and the outcome of the legal education with the teacher's mind to have insight into these versatile careers, which means they have to understand how legal practice professionals work. How do they work? If they are working at the preliminary level of helping someone to draft their complaint, or ensuring that FIR is registered, or in seeing that the opposite party does not jump the bail. So how do they do that? I mean, they may be prosecutors, or they may be well-wishers or support lawyers supporting the prosecution. So understand the importance of clear communication, identifying client's problem, whether the given problem is a problem in law. If it is a problem in law, it has to be tweaked to fit into the provisions which are relevant there. and your advice must match with that. Now, professional legal attitude. How should a student be inculcating that professional legal attitude than being very casual in terms of learning the law? And ongoing, that professionalism is ongoing. Our rule of uniform, and we create them a student bar association whereby we try to develop them. And then we have those procedures. As a teacher, see, today I'm addressing you as a teacher. As a teacher, you are not just an information delivery machine. You are an administrator. You are the owner of quality in the institute. You are the person who is mentoring future generation of lawyers, or I would use the word legal professionals, because today there are 120 types of legal professions, and today even body corporate can be accused of a crime. It's not just human beings in a social context that we are dealing with crimes about. So let us be aware of this changing scenario and complex scenario which is in front of us as teachers, and be ready to that, to tackle that, and ready our students to tackle that reality. Now, when we are teaching law, criminal law, we are not just teaching it as, Bharatiya Nyaya Sanhita or Sakshya Adhiniyam or rules, we are teaching it as part of a larger whole, which is criminal justice and administration. So there is something more than arguing the case in the court or reading a reported case from SCC online or AIR. That something more is that what link it forms in the larger aspect. I'll give you examples. Now, constitutional and global context of criminal law cannot be ignored. What is the constitutional context of criminal law? What are the rights of the accused? He is accused, and you can use the word condemned person, 100%. No, the accused is also a citizen of this country. We have marched as a civilization. So people are not condemned like the old gladiator days of the Roman Empire or the cruel treatment meted out to the accused. So accused is only accused. He or she is not guilty until evidence is proved. That is the march of civilization that we have. One of the famous writers, Michel Foucault, the postmodern philosophers, he talks about, there is a book by him on crime and punishment where he talks about how punishment varied or reduced in degree of pain inflicted, not because there was any challenge, but because civilization itself felt ashamed or disgusted about the way it was paining the way it was meting out the pain to the accused. So like the cruelty, public exhibition of cruelty was withdrawn step by step as the civilization marched. Let's not forget that. So Constitution is a torchbearer of that civilization and citizen protection. Therefore, it balances this beautifully, because even the condemned person ultimately is a citizen, and that person is not created out of vacuum. Therefore, rest of the society is responsible, as Gopal Subramaniam mentioned about that underage accused in Nirbhaya case. Now, global context is the human rights dimensions of this, and human rights of the victims or survivors as well, and how the whole crime punishment aspect is not complete in itself. The reparation aspect, the compensation aspect has to be coming in along with the retribution aspect of criminal law. The four theories of criminal justice. When you're teaching to students, please don't forget these four theories of punishment. Always you bring it in, or you just inculcate that critical insight. Because as judges, when they say it, they have discretion. And if those discretion is mired in bias, they may be doing more of injustice than justice. Therefore, it is not the duty of the teacher to fully be responsible for any consequence of the future, but teacher can always raise that point so that somewhere in life the student remains. Now, teacher's challenge today is to align the content of the lecture, the pedagogy, the type of the method that is used, and the assessment with the outcome of the course and outcome of the program. For example, if the outcome of the course is to have knowledge, what kind of knowledge? So the content has to look at that. If the outcome of the course is a skill, then you will use that, you will develop that skill either in the pedagogy or in the assessment, maybe collaboration skill, maybe project management skill. So aligning the content, for example, will mean if you are giving the different types of crimes are being taught in the criminal law, in the penal code, and then different procedures are being taught in the procedural code, how will you align the two? So we created a new course called Criminal Law Skills, and within that course we are giving them proper orientation, and a mock trial is the hallmark of that course. It is internally assessed. So for assessment we have different rubrics. Suppose you are assessing in the theoretical course, then you can sharpen the knowledge. You can teach them with those kinds of examples in the class, give them modified examples, and you can assess them the capacity to apply the law. So graduate attribute in terms of program outcome, you may be saying ability to spot the law, describe the law, apply the law, communicate to the clients, solve the problem. So these may be the graduate attribute that you may be wanting in the lawyer produced by CMR or your respective institute. How do you see that in your pedagogy and assessment and content? You are going to achieve that through the course of criminal law. So this is the challenge that the teacher has, and NAC has revised its criteria. It is looking at program outcome and course outcome, if you know, outcome-based education. So first, the student has to be taught how to ask a criminal law question, because we are talking of criminal law. So criminal law question, what do you say? What can be the criminal law question? Can any one of you tell me? If you have the option of opening up your mic and saying, otherwise in the chat line, what is a criminal law question according to you? If you are teaching criminal law, you can. If you are aiming to be a teacher of criminal law, you can. In my opinion, everyone is a teacher of criminal law. Even if you're teaching international law, we have a chapter on international criminal law. If you're teaching corporate law, there is a new era, new range of corporate crimes which are coming up, which may be bordering on monetary economic offenses. It may be bordering on white collar crimes. And if you're teaching cyber law, whole world of using cyber medium as the channel of offenses. So, or if you're teaching, let us say, something as harmless as contract law, doesn't criminal law come in there? The idea of public policy, if it is a contract for killing someone, so public policy comes, it is illegal contract from the beginning, because the consideration and the what we call as the purpose of the contract is illegal. So criminal law question can be asked across the discipline. But what is this criminal law question? Can you give me examples of criminal law question? Those who are teaching criminal law, those who are not teaching criminal law. Otherwise, I will tell. The criminal law question most of the time could be spotting the crime, or it could be interlinking a wrongful act to the context and asking the questions. Like I gave you, contract law. I interlinked the contract. Nowadays, supari killing, for example, in our Karnataka, they use the word supari killing. So supari killing kind of thing. So you spot the crime there. You could spot the crime in many other activities as well, which looks apparently innocent, but then criminal law will talk about what causes harm to the larger society. So situation, we sometimes teach by giving a situation that X did this, why we have in IPC plenty of examples. Misrepresentation, deceit, fraud, making someone to hurt someone. So if someone's body is hurt, property is hurt, someone's name is hurt, if someone is damaged, not simply damage. If it is simply damage in terms of loss, it comes under tort law. But if it is done with that, motive, malice, intention, these are the MMI. These are the three ingredients which distinguish a wrongful act, otherwise wrongful act, which may also pass off as tort, to crime. So if it is loss, then it comes under tort, because it is violation of a right, violation of an interest. But if it is harm in terms of seeing that there is a larger motive to be fulfilled. What could be that? Because you are a business rival, or you are someone who is having a property dispute. I mean, I was reading about Indian prisoners in death row. 80% of the prisoners were there for 3 P's: passion, property, poverty. So, reading these extra literature and bringing them to the class will make students feel that you are an interesting teacher. Only that teacher will survive who makes teaching interesting. How do you make teaching interesting? The novel element comes from the novel truths which are brought to the table. The novel truths for us is that day's news, that day's news item, some film which has come, or some kind of new crime which has been reported. So you have to be very alert. Many teachers maintain their notes from the time they were students, and then they oversimplify it, and then they think coming and telling in the class is enough and you get your salary. No. Today's student is very, very bright. Today's student has all the information and comes to the class. They may even end up correcting you because they would have read it more than you would have read it sometimes. So it is better to assume that your class is a class where people who have already read, your duty is to take them into the legalese or the legalities of that, because that is where you are strong. You have learned longer than them and you have learned the higher level of studies. Therefore, when you are making it interesting, you are taking it from the known to the unknown. So the known is that day's news item. The known is somebody's statement. The known is some film which has been released or some new YouTube video. Only 1 or 2 minutes. Please don't make your class only about it. You don't forget your curriculum that you have to deliver, what they call as syllabi. But linking it to the contemporary development makes it more interesting. Raising questions. I'll show you. So this is how we make it interesting, making them think. Because 21st century is about higher order thinking skills. Higher order thinking skills are used in PhD. They are used in, basically they are thinking skills which are used in critical analysis, where you describe and not just describe, you distinguish, you diagnose, and you compare, and then you conclude, you synthesize. And you don't conclude simply for the sake of concluding, you will conclude with valid reason. So this is the kind of skill, higher order thinking skill, whereby you are able to arrive at the new premise in thinking is what is expected in 21st century skills. That's why we ask a question. After teaching an undergraduate student, if you are also asked to teach the postgraduate student, is it the same approach? Some of my teachers do that. Before I took over here, postgraduate and undergraduate students used to sit in the same class to learn some legislation. So I told, no, stop. Because postgraduate student is supposed to bring knowledge to the class or be a partner in the knowledge. How do you do that? This is where you do that, distributing topics or project-based learning, and they bring it to the class. This is a flipped classroom where you don't teach, they teach. So we can't do it in the beginning, because in seminar method of teaching, we follow this, where we divide the whole syllabus after doing the fundamentals of every module and describing basic concepts. Certain topics from the last few modules we distribute among students so that there is enough time for them to prepare. Then they prepare and come to the class, where each module's final analysis is done by the teacher. So this is co-creation of knowledge by the teacher and the student. That is the era. I mean, we all learned it as master students under the able guidance of our teachers. But today, honors students, 4th year onwards, current students are capable of doing it at any point. But what you give to co-create the knowledge or to bring the information to the class is requiring lot of planning on the part of the teacher. It requires you to collect lot of references, to arrange them in a certain way so that students are finding answers to the questions that you raise, and they read and come, and then you clarify that in the class. So pre-class reading, during the class discussion, post-class reflection moments characterize the 21st century classroom or characterize a class where you are calling that class as critical thinking class. So let us come back to the courses that we teach in criminal law. So for undergraduates, we are teaching typical penal code. Now we have a new name to the penal code. So when you're teaching, you are giving, first you give the overview and then you take to different exceptions. First you give the overview, then you talk about the liability, then you talk about the exceptions to the liability, and then you come to different categories of offenses. So the whole scheme has to be explained to the students, and then more dwelling on liability is very important, because without basics of liability, exceptions cannot be clear to the student. And then you will be talking about each category of offenses. As you teach, you will be giving the provision, you will be giving the interpretation by different authors, different interpretation by different cases. Please try to see that you don't give a case of 1980s, latest cases. And then now with the new code coming in, a comparison between the two codes and the numbers of the provisions and alterations of the provisions, if any, have been done, the reasons for those alterations. So when we teach the course, we have to be mindful of the level at which we are teaching. Are we teaching a postgraduate diploma? Then the level is 3. Our postgraduate means general graduate. They are as good as law students who come after the 12th or degree. If you're teaching an undergraduate law program, it is one level above, because they are supposed to learn knowledge, ethics and skills. If you're teaching a postgraduate, then it is higher level than that, which we call as the 5th level. So 3, 4, 5 levels, in these levels, the emphasis is more on the type of knowledge that you bring, the type of teaching then varies, and the type of assessment varies. So please remember this. And then the outcome of the course, what kind of learning objective you have and what kind of learning outcome. The objective may be students will be able to comprehend, students will be able to apply, students will be able to analyze. And then when you go to level 5, it will be students will be able to critically evaluate. They will be able to give the opinion. So this is how learning outcome is. So objective is to impart knowledge, to discuss all these objective verbs, and then learning outcome verbs. The sets are given. I'm giving you the source of that. So this has to be aligned with the kind of program and graduate attribute that your university has identified. And then the linkage to quality, as I already told, how much of knowledge, how much of ethics, how much of skills. Now, if you look at that, now for criminal law, we have the National Indian Criminal Law Framework, the codes and their recast avatar recently, and the emerging issues that we have to see. So if you are looking at learning outcome in law, there is Bloom's taxonomy, which we talk about below. So if you look at the learning domain, I have given you the before that. So taxonomy levels. Bloom's taxonomy of cognitive domain has been identified to have these. How many levels? Just look at there. There are 6 levels. First level that student is expected is to remember. Now with the artificial intelligence, my son used to say, when I asked him to learn tables, he used to say, what is a calculator for? Why do you torture me? So remembering, although it stretches the brain to some level, remembering, if you look at the ladder of this taxonomy, it is at a very basic level, because the brain has to be engaged more in questioning. The brain jig has to be, or brain gym has to be, it has to jump, it has to twist, then only brain muscles will be stronger, which means that remembering, understanding, after you remember the provision, when you remember, do you understand? It is like people utter mantras and shlokas. If you ask them what does it mean, many do not know. They can tell the mantra. So knowing and telling is different. Therefore, knowing and remembering. Therefore, understanding is higher than remembering. Not and remembering and understanding together will be better accomplishment. And then the capacity to see its reflection in reality, that is applying. And then analyzing that this applies here, but it doesn't seem to fit. It doesn't seem to fit all contexts. That is analyzing. And then evaluating what are the strengths, what are the weaknesses, what are the gaps, and then you create solution or you create new knowledge, which is another area altogether. That is how the degrees have been identified. And now you see in India, the whole idea of forensics has been emerging very strongly, not just relegated to the scientific sphere. When we were students in institutes which used to teach criminology, forensics used to be taught. It was bereft of any implication for law learning. Today it is brought in. Therefore, what we see here is creating the new category of ideas. So when you're teaching criminal law, if I had one teacher who taught by bringing an activity to the class. That activity was, he was a retired police officer before he joined law, before he started teaching law. Before he started teaching sociology. So he combined with the law teachers and he created an exercise, creating an investigation scene. And so he created these mannequins who were kept as murdered bodies. And then how a few students who act as police officers, how do they apply the legislation? How do they apply the procedure? So the whole thing was recreated. Now this is taught in Judicial Academy, but do we teach in the law school? So this is where Bloom's taxonomy in terms of the domains, different domains of human intelligence to be applied. Now the students will never forget it. Large majority of that batch opted for criminal law. Then the person got transferred and he took another job in National Law School. He left us. But the imprint he has made, that best practice we cascaded across all Symbiosis law schools. And to this day, we have a paper on forensics, which Bar Council has made optional. Earlier, it was mandatory. So students would have National Forensic Science Laboratory person coming and demonstrating, or they have the field visit. So do the field visit. But better will be recreating a scene because they can connect the provisions then. That's what they are learning and interpretations. And they can see how far an expert witness of forensics is important in determining the fate or outcome of the case. So I'm just giving you from my experience some examples some of you are teaching. So when when the students are learning, now we told how the pedagogy is, how outcome is connected, learning levels, etc. Now students can learn. Of course, I know more about this. 7 different learning styles are there. Some people learn visually, some people learn orally. Therefore, making students make presentation, that is some of the students who don't like reading, make them make presentation after reading. They make a better, they get better scores because they really learn as they like to put it visually. Some students sing song way, they remember their lessons. So learning can have many facets. So some are looking at knowledge, what they know, which is cognitive. Some are affective, where they see this murder scene and remember. So growth in feelings means from the heart. They feel, some know, some feel. Some do, where they physically engage. Take them to the prison clinic. Ask them to sit in the counter and talk to that officer and take out the file. How many prisoners were for how many years? And what are the kinds of rights which are there? What kind of suffering they have, the prisoners? That is the psychomotor, where they have to go, observe, understand, spend time, ask them to present a drama in the prison on one special day like Independence Day. Then psychomotor skills. Some of my students are very good in law theater, where we bring a criminal law problem or interesting case like we had witch hunting once. Another time we had the theme. They will practice for 1 month with the National School of Drama person. They themselves generate a script which has some Bollywood influence, but it is with the original case which is decided by the Supreme Court. And then they learn better. And seeing that 100 students involved in the drama, 200 viewers or 400 viewers develop interest, they go and read more. 1 year we had Rohingya case. So international human rights law, trans-border child custody. They read because otherwise nobody would have read about CARA guidelines and family law. So these are the different ways, psychomotor, affective and cognitive ways of learning. Is your teaching pedagogy, is your assessment, is your way of delivering the information catering to all three domains of learning? This is the question I would like you to ask to yourself, how far you can accommodate. Now, what do we create in a program and course outcome? All of us want to create law professionals, right? That is the first and the foremost thing. Kids will tell invariably, I want to be a corporate lawyer, as if criminal law has no implication for corporate law. Finally, that company, in its premise, if somebody has been harassed, somebody has been murdered, criminal law will come, right? Or if one of their products has resulted in poisoning of somebody, or the way they are leaving the sewage to the local river or something, they will be. So corporate is not criminal law agnostic activity. This is what we have to convince students. To be the so-called corporate lawyer, first you have to be well versed with the trial lawyering, and then you have to be well versed with the appellate lawyering. So lawyering skills are core. What are the effectiveness factors for lawyering? There is a Berkeley factor. There are John Hopkins and other surveys. So I have brought you the latest one, which is a Berkeley factor. They categorize lawyering skills into 8 umbrella categories. So how do we create course outcome and program outcome? We can connect to these. One is intellectual and cognitive, where they are able to analyze the law, reason the outcome of the law, innovate ideas, solve the problem, give practical judgment. So you design your question paper or you're teaching in this way, at least one activity. Next, research and information gathering. You are giving assignments. So you are asking them to research the law, find the fact, question and interview. Suppose you are doing clinical activity, like for example, community legal service. So they may be going to the prisoners and talking to them. So there is questioning and interviews. Or they may be going to the forensic lab and asking questions. So that is it. Then communication, how to influence, how to advocate, how to write, how to speak, how to listen. Client counseling, mock client counseling. A client who comes and says that my neighbor is dumping obnoxious substance to my compound. Which law? So, which law? And because the neighbor once had proposed to me that they want to buy my property, I refused. Then it is criminal law, because there is an intent there. There is a design, there is a motive, either for profit or ill will. So this deeper nuance of criminal law will create a situation, same situation which is otherwise interpreted as tort law, will be differentiated. I hope all of you know this. Next is planning and organizing skill. How do you plan your essay? So don't just declare assignment. First 2 weeks you ask them, bring me the outline. So that shows if they're planning and organizing well. It is also about, in the mock trial or moot court, how do you divide the role, and how do they divide role among themselves? How do they get ready? How do they align those different pieces together? Our classroom is preparing them to be lawyers. Our institute is preparing them to be lawyers. Don't forget that. Conflict resolution, for example, plea bargaining we have. Sometimes, in dowry cases also, cases are withdrawn because there has to be a remarriage if these couple are not going well. Then negotiation skills in such cases, understanding, able to see the world through the eyes of the others, empathy. This is where artificial intelligence stops. That's where human intelligence comes into work. Client and business relation means providing advice, networking with other lawyers, referrals, or students talking to master students and getting it. These are all the ways by which business relation simulation happens in the law school. Working with others in their own group, if you give a group activity. Character building in terms of not plagiarizing, being honest, giving references, and being communicative and engaging in community service. So you can design your criminal law course teaching, assessment, and pedagogy meeting these Berkeley factors or important lawyering skills. So the role of the law teacher in teaching criminal law can have 3 facets. One is your own legal education context. What do they want to learn? What do they want to do? How do they learn? So this is something you have to visualize and then give these activities. And once you finish your first year, write down your reflection and modify next year. And also look at what is the latest. Unpacking yourself means you yourself will have to unpack yourself. You may have certain biases, you may have certain way of seeing, and you will have to make intervention if the student has that bias. I was once teaching maintenance law in the class, and one Muslim student stood up and said that under 125, whatever maintenance is given, it is enough for, it is enough. Muslim should not apply under that. I asked, and I had only 3 Muslim students in a class of 80. And rest of the class in the Mangalore's communal kind of environment, they were up in arms against this boy for raising that question. Then I was patiently asking, why? What, according to you, stops a Muslim from coming under this law? Why should they? He said that in the Holy Quran it is said that the woman who has been ill-treated by a man should not go back to that man seeking support to live, because it is against her dignity. So she should go to those who honor her. And according to Quran, they should go to, because they have right to property. So that part of the property, or there is community waqf, or they could go to the relative who has the responsibility to manage them. So this, or marriages were very openly allowed. I mean, if one marriage fails, another marriage was allowed. So only the iddat period to determine paternity, etc., was there. So I was really learning from that student, which I saw. I myself shared that bias, that why all our other laws allow and why Muslim law is seeing this secular provision as against their personal identity. I had that question, but then I understood that the level of dignity that is attributed to woman by her economic independence, and the husband who fails to look after her and not to be economically dependent on him, that facet was never known to me. It is not written in any scholarly literature. So he quoted the surah and he explained it from Arabic to English. So this is where we should be ready to unpack ourselves as we are teaching, and classroom could be a very dynamic, powerful exercise. Similarly, law reforms which have come in these most important areas like honor killing, which has been taken not as honor killing, one law for honor killing, but most of these laws are brought under, why are they brought under criminal codes? Because criminal code is the most effective. So, and faster in action, because it is a very systematic investigation. Uh, to be honest with you, or no, to be more politically correct, in comparative law, I was reading a chapter where it mentioned that the most colonized law in the world is the criminal law. What the colonizers took wherever they went through the length and breadth of the world was a criminal law. They claim that they rationalized crime and punishment by bringing British criminal law everywhere, because the systematic way of providing evidence and gathering evidence and proportionality in terms of crime and punishment or malice and punishment was the rationality they brought in. Therefore, that was the most colonized, that was the most spread out law, or they go to the extent of exaggerating that it is the gift of colonization to the world, that rationalizing criminal law. So the origin of this criminal law which we have has come from the Roman experience, and from the Roman experience it moved to the British, and from the, even in Europe, and then Europeans limited to code, whereas the British, along with that, they brought in the common law, case-based law. But the code remained as it is. They never amended the code. We, after independence, we took the courage to amend many areas, and judgments have, in a way, either neutralized the code or they have added on to the code, which have later come to the legislature. I hope I have made myself clear. Now, as criminal law teachers, you have to be very, very mindful of these things, very careful than feeding wrong notion to the students. Now, the system context. What is the system context of criminal law? One is, no development of country, economic development can be happening unless the security is ensured. So criminal law plays that key role in determining and facilitating and defining this idea of security. Security arises out of absence of crime. So what is a crime is the understanding to know the idea of security. So the criminal law and security are mutually bound up with each other, and security is the foremost fundamental aspect of right to life, without which the actualization of right to life doesn't happen. So many objectives it may serve. Now we are reading a lot, especially with the onset of the social media and technology, the date rapes, the media intervention, political killings, trollings, hate crime. So system context of criminal law has to be read. Even if our current laws, now the latest version, the avatars have taken into consideration cyber crimes and online offenses, etc., but may not be to all extent. We don't have to have a separate criminal law for online. Existing criminal law, same logic, same structure, considering these offenses. For example, somebody told me about animal euthanasia. Have you heard of that? One of the PhD students made that proposal recently on animal euthanasia. Imagine, we all think about euthanasia, but we also have read about animal rights and legislation on animal rights. Now, euthanasia to be inflicted on the animal, who has to decide who is the next friend? All those questions which come in human euthanasia come into animal euthanasia. So, as a teacher, when you teach, this kind of creative interpretation and connections that you make can be possible if you are very deeply reading these things and asking those reflective questions. Now, justice. What is attribute of justice in criminal law? Is it retributive justice or distributive justice? It is retributive justice, because basically the principle of justice is do no harm, which means that you can also look at negotiate, plan, act, and resolve the cases of crime and prevent the crimes, criminalize or decriminalize. Now, some things have been criminalized. For example, sex work has been criminalized. Can you decriminalize? You can't unless you do the stakeholder-based analysis. And it's very clear that more than 50% of the sex workers have been trafficked as children. They have been, rest of them as adults. Nobody has consensually, voluntarily gone into sex work. How could you decriminalize? The minute you decriminalize, everyone is scot-free, one who is associated with the trafficking, etc. Therefore, very carefully bringing these discussions into the class is very important. Is criminal law standalone while teaching criminal law? No. It has to have very good grounding in jurisprudence. Please read Salman Dias's jurisprudence on criminal liability. The liability chapter clearly demarcates criminal and tortious liability. The forensics cannot be independent of criminal law. For example, have you read about the Innocence Project Netflix serial? Anybody? So in that, it is a Harvard project where they go back to the Mississippi and all these black dominant areas where the blacks have been in the death row. And then they realize that all these have been possible because of the forensics. And the forensic dentists have given reports on particular rape cases where the bodies were found in a pond, that a black man's tooth marks are resembling these marks found in the body. Only 20 years later in the Innocence Project, thanks to the Harvard law students and committed lawyers, it was brought to the light that the shape was not of the tooth of a black man who was alleged to have committed the crime, who had his own mental illness and other problems. It was due to the sucker fish, which was very unique to that pond. So, I mean, even if you have those broad incisors, how could you bite with the same intensity all your victims? So these questions raised by lawyers finally resulted in many people being taken out of the death row. So when we teach crime and punishment, let's not say IPC so-and-so says, defines the crime this way, punishment is imprisonment or fine or both. No. How this whole, I mean, my teachers used to bring the Bear Act, read, and they used to say, but I would have thought about in reality how it translates. Therefore, very important to contextualize it and read it with cross-sectionality that it has with forensics, with constitution, with human rights. For example, bail is the rule, not jail. Now, when the bail is granted to someone, we are very unhappy. But if the bail is not granted, then prisons get crowded. If the bail is granted, the threat of witness manipulation or threat of threat to the survivor is always there. So can the government also talk about bail without guaranteeing the security? Therefore, there are conditional bails. There is a bail bond. But is that enough? How many reports have come? This is where the research questions can be given to the students. Is it only professional training to be lawyers? No. Now, with all that we have discussed, it's very clear to you that teaching criminal law is not only moving towards court-based law professions. There are larger professional possibilities which exist there, to which our versatile teaching and training need to cater. And then how social control and governance happen through criminal law. And there are other ramifications also. So expose those dimensions. Now, coming to human rights and constitutional perspectives, which are the issues and concerns in criminal law, we have fair trial, we have impartial investigation as an element, de novo investigation if the investigation has not been fair, if it has been influenced, you can open the case again. It happened in Jessica Lal murder case, as you know. Individual liberty of the accused to be protected, bail not jail as the rule, and prison administration criticality to be brought in. That's when you take them to the prison, they will realize. And process. What is the process in terms of teaching criminal law? One is mapping or marking through investigation. What is the methodology in case of crime? And then prosecution, media, judiciary, post-conviction, role of the public. This is the whole criminal law process that has to be laid in front of students, either in the criminal procedure code or in the Indian penal code or the cognate new laws when you're teaching them. I mean, if you just, so in the beginning only, if you are able to bring the file of a criminal lawyer and track the documentation, and also give them mock cases of giving a situation and asking them to draft a complaint, and then matching it with the section, they will know how to think like a lawyer. That is very important. And the concerns, special concerns, women, children, or third gender, and how they are vulnerable to the bias in the court, or they are treated like anyone else. For example, I am a poor litigant who is in front of the judge, and judge says next date. And then how will I come? Or I am a young schoolgirl who has been sexually harassed by my tutor. And then I'm told that I should explain this to the judge. And I become so melted in the court of law. I start crying. I'm not able to speak because, first of all, I don't know if I am also wrong, whether this is my doing. You know, most of the time children think like that. If their parents are separated, they think they are the cause. If there is any abuse, they won't tell others because they feel this is I must have done it. So this is Carol Smart argues about how court also becomes a difficult environment for example, the prejudice against a woman who ends up murdering her husband after being victim to multiple incidents of domestic violence. Her whole psychological frame is not understood, and she's condemned by everyone, looked at with prejudice. Do we bring it to the classroom? These novels, these stories. In Kannada, we have this author Chaduranga, who has written a novel called Mrigaya. It is about the illusion in Ramayana. Mrigaya is illusory animal in Ramayana, the golden deer. So Mrigaya is the novel which talks about how judge, when that client stands in front of him, judge recalls his own encounter with an abusive wife and tries to see this person as a reflection of that and ends up with the harsh punishment. So these are the creations of creativity, but they are very much having correlation in reality. And in rape law, whether the norms are objective, aren't they subjective norms? This was the question that was raised by Ratna Kapoor. Subversive sites, about domestic violence, about home being a subversive site for women. And in Vimochana in Bangalore, the NGO held the public trial, and they wrote a book. They said how in the witness box the families were crying after not accepting their daughter when she came back with the first experience of violence, which finally ended up in her suicide or murder. So this is one. And what are the rights of the citizens? And then we have extra legal killings, which are extrajudicial killings or encounter killings. The incarceration risk in cases, overcrowded jails, these issues have to be familiarized to the students. When will they learn otherwise? So students have to learn and unlearn and relearn. For example, I was searching for a script at this age with this much experience for witch hunting about Salem's witches in the American and European context. Then suddenly I stumbled upon a decision by the Supreme Court, and I realized that in India, in 3-4 states, witch hunting is still there. Now, this is what you realize as a teacher. And the situation of Mangalamukis in Karnataka, for example. So, how exactly Mangalamukis happen? Is it by birth? Is there a kind of ritual that they go through? Then, why do they do this? Is there also a criminal attempt behind that? What kind of rights consequences they have? How does criminal law treat them? We in Maharashtra, we trained 300 of them to protect themselves against police atrocity as paralegal volunteers. So students can be involved in this, or you could plan this as a teacher, with interviewing them, client interview, and remedying them, bringing them to the legal services authority. These are the things you can do. Now, in terms of clinical learning or learning by doing, which I told in the beginning, mock trial, moot court, lab visits, forensic lab, court visit, police station internship, prison clinics, simulating a client in the class, all these are the ways. Therefore, broadly, teaching methods have a case method, problem method, where you bring a problem and you formulate a draft, role playing, where they act as two lawyers and the judge, multimedia, where you look at films like Talwar on Arshit Talwar murder case, or Do Aankhe Bara Haath about different witnesses, Roshoman, how witnesses twist their statement. I had also seen a movie called Raz about witness protection. Long, long ago, such a movie had come. Drafting documents, modeling, how do you create the model, out of class and online teaching, how do you do the online teaching, creating study groups, team activities, tutoring means what you taught, you you would have taught one case in relation R versus Tolson. You want to teach many cases which have come in India recently and later on. So there you have a tutorial and have those multiple cases, give advanced reading to students, let them discuss in that tutorial, which you can't do in the class. So also there is reviews, means I give reading groups to students because they don't read and come. So I divide them into groups, give them 15 minutes, give them an outline of questions. They read and they bring back the essence. So one group reads, 10 groups learn. 10 groups read, one group learns. So the reading gets multiplied. Then teaching ethics in relation to criminal law. Speluncean Explorer, what you call Dudley versus Stevenson case. I don't know how many of you have read. The man hunting case where the sailors set to sail and they get moved, and then the youngest fellow is killed by them and then eaten, and then they come back and then they try to explain it as necessity, whether they are guilty of manslaughter or murder. So these are the kinds of discussions you can raise in the class. Now, case method is one method. How do you do the case method? Outline of the case method I have in that video. You just have the brief of the case, anatomy. You divide the case into parts of law, its procedural history, the issues, the rules, and what is the decision of the court. So you can do it in role play, debating, themes and conclusion, law theater. So they climb, the ladder of learning. And basically syllabus is that kind of a learning contract between you and the student. Some of us run the syllabus, we don't pay attention, which needs so much of reflection, reading, and original energy put into it. Then it becomes very, very interesting. So in the case analysis, how do you teach the case analysis? Issues, how, who, why, what is the known information? Is there any missing information? What are the dates, monetary figures, and you track. And then the rule governing the resolution. And then the analysis and application, whether this party, that party, who has a better claim, then conclude like a judge, who has the strongest argument, liability, how to avoid what we call as in moot courts, what do you call it? Counter analysis. So in India, when we are looking at it, political, economics, and other crimes cannot be avoided. Today we have ecocide as a crime. which is ecology related crimes, killing the environment, animals, environment, human animal conflict, another potential area for criminal law. Penal consequences in civil cases is also another. For example, presenting a forged document in a civil case, that could take a penal consequence. So this is what we teach. And then how do you look at an act or a legislative provision? So there also you have to see, is it new? Is it amended? Is it legally sound? Who has the rights? Who has the benefits? How is it dealt with? Is it compensation? Is it punishment? Is it retroactively applicable? Who has the accountability? What are the authorities? Constitutionally, is due process followed? Is there any implication for human rights? Who have the power? What is the penalty? What is the role of courts? Is there appellate power? So these are the questions we ask. Now I bring you to the most interesting part, very colorful slides. 7 different facets of how we could teach criminal law now and in future. So are you familiar with the idea of deep learning? It is not just reading the provisions, it is learning it deep in terms of its all facets. And the machine learns them deeply and gives it back to you also. So 21st century skills, how do you connect to this? Who takes ownership of learning? What is critical thinking? So quickly, if you are using traditional method like lectures and seminars, if they're interactive, it's good. Otherwise, it can be boring. Problem-based learning, where you can modify the case laws. Cooperative learning, where students divide into groups and bring back, as I told you, many cases, if you're teaching. Project-based learning, where real-world problem you pick up and then send them to the field, and then they study and they come back and you connect it to provisions and they make a presentation. Service learning, like District Legal Aid Services Authority, or helping the vulnerable groups like children or prisons. Flipped classroom, where you send readings in advance, they study and come and you conduct the lecture. And collaborative online international learning and massive online courses. These are the kinds of modern approaches. So Generation Z doesn't like to be told. So they like virtual integration, museum visits, artificial intelligence. So these are the kinds of things that you have to bring into your teaching, where you use your students in platforming or gamification or Google groups. These are all the different ways of learning. So in traditional teaching method, little engagement of students is there, no personalization, no interaction, limited assessment in the class. So this is the weakness. On the other hand, when you have open discussion, it is, what do you think? I'm sure all of you will say that traditional teaching method is not working with students. So we start project-based learning, which is not a new concept, but here students engage, they develop a skill, they have a deeper learning because they discuss in 3-4 ways they connect to the topic. The weakness is that it needs a lot of planning, lot of resource and lot of time consuming, and difficulties. One may do very well, other may not bother, but they will get the marks. So you will have to plan your assessment. Common marks may be 50%, rest of the marks based on the contribution which you do the viva and verify. So here, is it worth? How does it develop skills? That's what you're asked. Problem-based learning is where you give a problem and then you see that problem to be solved and how do they apply the skills, what kind of motivation they have, how do they collaborate. Again, it takes time. Many teachers are not willing to adapt to problem-based learning or assessment. Then we have service learning, I told you, where service assignment resulting in helping someone, at the same time students learn and they develop many skills. So in problem-based learning, you can give developing a defense or prosecution argument in a particular case. In project-based learning, you can look at whether a witness protection scheme is implemented in how many cases. Service learning can be mental hospital or domestic violence victim home or legal aid clinic in the district learning. Cooperative learning is where you divide the activity and many of them learn and you bring them back like multiple cases. And here also social skills develop. A classroom management becomes easy. Flipped classroom is where you give the reading in advance. Students bring the learning, you empower the students and you interact and you develop with an outline that you have. So you send out the material first with that outline in the mind. When they come back, you develop it further. So here, access to technology may not be there in poorer law schools, so that might be a limitation, but you can try and do your best because everyone has a mobile phone. We ran clinics through WhatsApp groups during COVID for rural women. So I don't think our students are that impossible than these rural women. So collaborative online international learning, we did a project on the concept of good faith, where 4 universities from 4 parts of the world came together, contributing 4 students. In their own jurisdiction, they saw this concept. Then all of them came together and developed a synthesis of what is common, what is uncommon, what is the best practice. So this way we can plan between 4 institutes in India or 4 institutes outside, intranational or international learning. Now, where do we stand? How many of you can teach this way? We need digital literacy of the teachers and students and training in using the AI like ChatGPT. Now, how do you use the ChatGPT? You don't use the ChatGPT by giving in a prompt and then copy pasting the information. You can test the students in terms of the best prompt to be given with this information. You reverse it and ask students, then you will know that they can't copy easily. So overall, this whole learning in the current and future approach should be integrated with the student-centric ways to make it interesting, to make it techno-savvy, and also to enable teachers to see that Indian realities are brought in the field of criminal law teaching and criminal law research. So I stop there. I thank you all very much for this opportunity, particularly Dr. Subramania sir for this innovative idea. I also express my thanks to our collaborators in EU projects from Spain and Greece who brought us into the learning of 21st century skills, and then we researched, we contributed in a collaborative way. Thank you very much. If there are questions, we are open to the questions. Your feedback on the chat line is also welcome. Over to the compeer. Thank you.